Next case on the docket is Stewart versus State.
Good morning. May it please the court. My name is Bryn Newton, and I represent Edward Stewart, who was convicted in the Brevard County Circuit Court of armed burglary of a dwelling and sentenced to life in prison. The evidence convicting him of the burglary was his statement to a Palm Bay police detective admitting to breaking into the house, and he moved to suppress the confession. What we're not asking you to do is to reweigh the evidence or judge credibility of witnesses. You're not disturbing any factual findings when you review this, the judge's ruling. The state agrees that the application of the law to the facts is always reviewed de novo. The only finding the trial court made in this case was that if there was a promise made for the confession, it had no legal significance. And I believe that is incorrect. The state has argued that if there's no quid pro quo, it's okay to make promises or suggestions of leniency. But this court last year, in a host of other cases, says that if a statement is not free and voluntary, if it's elicited by direct or implied promises, however slight. And the Supreme Court in Trailer reiterated that it doesn't have to be a direct promise. What you have before you is a police officer who just doesn't really remember whether he told the defendant he would go home that night. And besides, he doesn't really regard that as a promise. It's just a description of how the case will go. We've got, once again, a case where you've got a lot of the interview on tape, but not all of it. And in this case, you don't have the crucial part. If this conversation took place, it would have taken place on the walk to the interview room, where the officer was merely describing how the case will go. We'll talk about the cases, you'll clear up some burglary scores, and you'll go home tonight. And there is no more enticing promise to a person in custody than you're going to go home tonight. It turned out to be for 3 or 4 days, but he did go home. So the trial judge said promises were kept. It's all right. It's free and voluntary. Any questions?
Okay, thank you.
May it please the court, good morning. My name is Kelly New, and I'm here on behalf of the state of Florida. There is another prong that must be reached in making this promise. It has to be calculated to delude the defendant and exert improper influence over him. And we have no evidence in this record that this deluded the defendant or that there was any improper influence exerted over him. Even if the detective told him, you can go home tonight, it wasn't, if you tell me all about all these burglaries, then I'm going to let you go home tonight. This man's a 4-time convicted felon. He obviously dealt with the criminal justice system before. There's just simply no evidence in this record that his confession was given in exchange for a promise of going home that evening. So based on that, I would ask this court to affirm the order of the trial court denying the motion to suppress. Thank you.
Thank you. Good. Lots of time.
In the 6th volume of the record at pages 266 to 273 of the trial, the defendant testified that it was the promise of going home and getting help with his drug problem, which is why he agreed to make the statements.
Thank you.